Hello, my name is Kate Jackson and I work for the Bodleian Law Library. In this session we're going to look at how to start researching for your moot problem. We're going to cover what to do before you start actually researching the law, how to actually start your legal research, how to follow leads to other information, and also what to do with your research once you've done it. You need to do a number of things before you start researching the law. Firstly, read your moot problem carefully to make sure you have all the facts in your head. Then determine which side you are arguing, whether you're arguing for the appellant or for the respondent. You also need to determine which point of appeal you're arguing for and against, whether you're lead or whether you're junior counsel, as you don't want to be researching the law for your partner's point. It is also sometimes useful to create a timeline for the events set out in your moot problem, so it's clear in your head when you're doing your research. And also have a look at the competition rules, as this will actually lay out how long you have to argue, and if you're the appellant, whether you have a right of reply. Once you've done that, then you need to start thinking about your legal research. And you probably need to get a legal background for the subject. Even if you're already familiar with the subject, go back again and have a look. You also need to find legal authorities to back up your argument. But whatever you do, just don't start typing or delving into books. To get started, you need to prepare a research plan so that you have an idea of where you're going to search. You also need to use the sources, follow leads, evaluate your information, and then also think about any problems you come across. So what should be part of a research plan? Obviously the broad topic you're likely to know, but also keywords and key concepts, so legal terms, any synonyms for legal terms you might already know. You also may find that you have case law or legislation mentioned within your moot problem, and these should be put down as places to start your research. You also need to start thinking about how you're actually going to find the answer. So what types of sources are you going to look at? Secondary sources, books, or primary sources, cases, legislation, articles, all these need to be thought about. So where are you going to find these types of sources? So what sources are you going to use? Relevant textbooks, relevant databases, article indexes, all these are useful when you're putting together your research plan. What can be difficult if you're not used to it is identifying keywords in your moot problem. Remember, you're looking at legal terms, not facts of the case when you're actually starting your research. A good starting point is what words and phrases the trial judge has used. And also you might find that your points of appeal have been set out for you, and these will include legal terms that you need to research. Essentially, what do you not understand and what do you need to know more about? All of these need to be down as keywords. If you've studied the subject before, you may recognise that a case that your problem is based upon, so put this down as something to research. In terms of choosing your sources, we recommend that you start with secondary sources. The work is already done for you, you don't have to interpret the judgments. It's also difficult if you're not familiar with the subject to actually narrow the subject down. Databases are too large, and if you don't have a background, then you're going to bring back too many results. Try a textbook, and if you don't have one in mind, then ask a librarian or search a library catalogue. Also use articles, search article indexes, and use that as your background. Remember other possible hard copy sources, there may be encyclopedias available or law reviews. So once you have this down, then you have to execute the plan. Obviously with textbooks and encyclopedias, use the index to find your key terms and look for synonyms that they may use as well. If you have a case or legislation, you look this up at the tables at the front and see which section it's discussed in, and that too will lead to other keywords and synonyms. If your keywords do not appear in the index, look at the broader subject matter in the table of contents and read through that particular chapter. It might give you further ideas. When searching for articles, remember to try and use the advanced search with the keywords identified. This will make your search more relevant. Another way of making your search more relevant when using the database is to use terms and connectors rather than just putting in words in the same way as you would with Google. This will bring back fewer results, and it'll also make them more relevant. Again, if you have a case or legislation, then use the advanced search and the article indexes. They often have a field for you to put the case name in, and that is a good way of searching. It is also important when you're building on your research to use case and legislation citators where possible. So if you do have a case already mentioned or you come across a case, then use the case citators to find out more information about them. If you're unsure how to use case citators or not sure whether you have access to them, then ask your tutor or a librarian and they'll be able to tell you. Another good way of finding primary sources or to find other material is to look at the footnotes. So follow the leads that you find in footnotes. A lot of legal textbooks have copious notes at the bottom, so use these to find further information on your point. You also find with articles and the articles index that a lot of the time, especially with something like Google Scholar, you get a link that links to other articles that have cited that article. So if you have a relevant article, then you can find other articles on that subject. Another good way of following a lead. So you keep going until you find you have enough to base your argument on. Essentially, you'll start to feel comfortable with the subject and your argument will start to become formed within your mind. But one thing to note is to stop if you come to a dead end. It is often quite easy to get sidetracked or to get frustrated because you can't find information you're looking for. If you can't find anything in a particular source within 15 minutes that's relevant at all to your argument or to your legal topic, then go back to your research plan and have another think about the terms that you're using. Once you have the information, you obviously have to evaluate your information to make sure that it's correct. It's important that the law that you cite is up to date. So with case law, have a look at this case citators and see it's still good law. Also look at subsequent treatment of case law. So again, using the case citators to see what other cases have cited that case and how it's developed over the period of time. This is particularly important with older cases where there's been significant developments over time. With secondary sources, always make sure that it's up to date. So have a look at the publication date, and if it is a few years old, then do double check just in case the law has changed on that particular topic. You also need to be aware, if you're using the internet for your research, that it's from a good source. So do check which website it's on, and if you're unsure, don't use it, or check a more reliable source. As a rule, anything on a subscription database is usually fairly accurate, but anything from a general blog or internet source you do have to be aware of. So you have your information and you have your research. What do you do with it? Essentially, you need to apply the law to the facts in your moot problem. You need to think about what you're going to argue, and you need to list or understand which authorities you're going to use to back up your argument. Essentially, when you have those 3 points for each point of your argument, then you can start thinking about your skeleton argument, and this will probably form the basis of your skeleton argument. As an aside, in terms of choosing the cases that you use to back up your argument, you do need to know, firstly, is it on point? Does it sort of veer off onto other parts of the law that perhaps don't back your argument up as well? Which court the judgment is from, and what court are you going to be arguing in? This is important in regards to whether the case that you use is binding on the court that you're arguing in, or whether it's just persuasive. And if you know that, you need to be able to explain that and why you're using that particular case. Also think about the jurisdiction of the case. Again, whether it is binding on the court or whether it's just merely persuasive depends on which jurisdiction you're in. So what if you can't find anything? If you can't find any cases that support your argument, it is worth going back and having a look at your research plan to see if there is anything you've missed. By now you will have built up a fairly useful legal background in that particular topic, so you might have missed keywords or you might have missed a particular part of your moot problem. Are there any sources that you've not used? Try a different textbook, for example, or search around for a different database if you prefer one database to another. It may be worth talking to your tutor if they can help, if this is allowed, or to go and have a word with the librarian to see if there are any sources that you've missed. More often you find that the cases you find actually work against you. So you need to check for cases that have distinguished that case. Again, this is where case citators can be very useful, as they will actually list these cases. And you can actually go and have a look and see how they distinguish the case. Also look to where your facts are different. Moot problems are often written so that you can argue that they're substantially different to the main cases on that subject. So once you're comfortable with your research and you know what you're going to argue and you have your authorities to back up your argument, What do you need to do next? It is worth having a look again at your moot problem to make sure that you've not veered off course, but also have a look at the competition rules. How much time will you have to argue? Will there be a right to reply? When and in what format do you need to submit your skeleton argument and list of authorities? And are there any restrictions on the amount of authorities that you can use to back up your argument? It is also worth going over your argument with your mooting partner. It is really important that you don't contradict each other when you're on the same side, as it can confuse a judge and undermine your argument. Obviously, you need to prepare your skeleton argument and list of authorities. Have a look at the competition rules to see how this is to be done. And then once you've done this, you need to submit this according to the rules. Before you get to your moot, you need to prepare a court bundle, which will be given to the judge. And this includes all the authorities you're going to rely upon, so all the legislation and cases. It is worth checking the competition rules to see what format these are going to be in. It is important that you make this as easy as possible to navigate, bearing in mind the time limit on your legal argument, and that you will have to wait for the judge to get to the particular point in the court bundle. It is also really important that you read your opponent's submissions to see what argument they're going to be using, and also be familiar with the cases they're going to rely upon, as the judge may ask you questions or pick up on the fact that you don't know what your opponents are going to be arguing. And of course, you obviously have to turn up on the day. Some common mistakes when you're researching your moot problem. Firstly, not reading your moot problem properly. Do go back as you're doing your research and make sure that you're not misreading a sentence or just a word, because that can make a difference to your argument. Also, arguing about the facts of the case. What's there in black and white is a fact. You're arguing about the law and not facts. Try to avoid reading your notes like a script. That might take a little bit of practice. I'll say again about reading opponents' arguments and cases beforehand, but also go over your moot with your partner to make sure you're on the same page. Not having a clear court bundle is also a mistake. It wastes your time and actually annoys the judges. Also, running out of time and time management. Be aware of how much time you have left. It is also important to have a balance between the principles of law and the facts in your case. You don't want to talk about the law and not tell the judge how they apply to you. I hope this has been useful. Thank you for listening.